The expulsion of the Senior Counsel Ahmednasir Abdullahi and associates of his law firm from appearing before the Apex Court for litigation purposes has attracted the interest of the Law Society of Kenya and has now appointed a team of lawyers to scrutinize the decision as it seeks a judicial interpretation on the rationale behind what they term as punitive action. Ruth Wamboi with details of the turn of events that could permanently dent Ahmednasir's legal career. Watch.
The Supreme Court of Kenya on Thursday barred Senior Counsel Ahmednasir Abdullahi from appearing before it. The court in a statement faulted Ahmednasir for what it termed as relentlessly scandalizing and ridiculing it. It is this turn of events that has seen the president of the Law Society of Kenya, Eric Theuri, seek answers on the criteria used to arrive at the decision.
The manner in which the Supreme Court acted appears to be extremely reckless, because it seems to us that they picked his many comments on social media, on Twitter, and perhaps comments that have also been made before the court and other press issues, did a combination of all those. Also, the nature of the decision that they made makes it extremely difficult for us to even understand the rationale that the Supreme Court employed before arriving at that decision.
Section 28 of the Supreme Court Act lists incidences that warrant a court to find one in a contempt and gives powers to the court to make an order denying audience to persons considered to be in contempt for any period as the court may deem fit, but not exceeding 18 months.
We are quite disturbed by what it means. It means that any other advocate can face the same consequences if the court doesn't like what you say.
We must be very clear, this has to happen during the sitting of the court, which means this is contempt ex facie, contempt on the face of the court. Now, the court is empowered to punish for that contempt. And the punishment is supposed to be a maximum of 6 months or a fine not exceeding 1 million shillings. Right? Now, the import of this section is that if the contempt is not on the face of the court, then the court cannot suo motu, or on its own motion, punish the contemner.
The Supreme Court Act gives 18 months at the maximum that someone can be barred for contempt of court. So the court barring him permanently, then they would have given us the authorities and other laws, if they exist, that have allowed them to do that.
Among the incidents listed as offenses include the event a person assaults, threatens, intimidates, or willfully insults a judge of the Supreme Court, the registrar of the court, a deputy registrar, or an officer of the court, or a witness. So what could have led the court to take this action, and is it the first time the Senior Counsel has found himself at the crossroads with the judges?
I believe there is one more time that he himself has actually professed that he was banned sometime in 2000, and maybe at the time that was something up to what the courts were able to do, but the new constitution doesn't allow it.
Whereas a section of the legal pundits agree the judges acted in line with the Supreme Court Act, they differ on lack of specificity in the period of time and ban against his associate. With the letter having reached at the doorstep of Senior Counsel Ahmednasir, what are the viable options for him to pursue?
This is bound to become very untidy, because you're going to have a scenario where the High Court, sitting as a constitutional court, will basically overturn a decision of the Supreme Court. It's not a very tidy way of doing things. Yeah, but that's the option which, in my view, is readily available to the Senior Counsel.
In my view, I was thinking we can go straight to the East African Court of Justice and appeal the decision, because I wasn't thinking of him going lower in the hierarchy of our courts.
It's now a game of wait and see what next as LSK moves to interrogate the ruling. Reporting from Milimani Low Coast in the county of Nairobi, I'm Ruth Wamboi.